Hi folks, this is part 2 of what to expect in a criminal trial. As you may recall, the first part I dealt with the state putting on their case and everything prior to that. Now it's my turn. The judge asked me, Mr. Franklin, and at this point in time my client and I have discussed what occurred in the first part of the trial of the state's case, and my client, him or her, makes a decision as to whether or not they're going to testify. Keep in mind that my client does not have an obligation, one, to testify because of his Fifth Amendment rights. You know, you can keep your mouth closed, you don't have to say anything. And if in fact he made admissions, he said some things that could be misconstrued prior to the trial, maybe it's a time for my client to get up there and correct those or clean them up a little bit, explain what he really meant. Or maybe he wants to talk about an alibi. He was at Aunt Susie's house that night, so he couldn't have done that. And he's going to talk about how Aunt Susie will come in later on and testify that he was there. These are questions I would ask him. So it's my turn to bring my witnesses in, and again, I don't have to. Hopefully the state has done such a bad job of presenting their case that I don't have to do that. And that's occurred plenty of times. But my client makes a decision to testify. He gets up there. I ask him questions that aren't leading. You know, not was the sky blue that day? And that's a leading question. The question is, what color is the sky? And then my client says it was blue. So that's the difference between the two. I'm not allowed by our rules to back him into a corner to get the answer I'm looking for, just to make sure everything goes my way. On direct examination, both the prosecutor and myself cannot do that. On cross-examination, now the state gets to cross-examine my client. And let's assume my client has prior convictions, felony convictions, or a misdemeanor conviction that possibly goes to truth and veracity. They may be able to bring those up during their cross-examination of the client, such as, isn't it true, Mr. Smith, you were convicted 10 years ago in Maricopa County Superior Court? And if the client says, no, it's not true, then the prosecutor, the doors open more so he can get specific, or she can get specific, as to what it was. You know, you were charged with armed robbery and you were found guilty. Isn't it true you've been to the Department of Corrections, things like that? If the client says yes, then you just move on. That's it. So now the jury's got a bug in their head that you've been convicted of something. A lot of people believe that nobody can be rehabilitated or pay their price to society and things like that, which means now all these people are wondering if everything you've said is actually accurate or true as opposed to a lie. Let's assume you don't have any priors, got a clean background. You explained you were at Aunt so-and-so's house that night. She's going to come in and talk to the jury about that. And then I call my second witness. I call in Aunt Susie or whatever I said her name was before. She comes in. She says, your client was at my house that entire night. He got there at 6 o'clock and ate dinner and didn't leave till 6 o'clock the next morning. And the armed robbery was at, let's say, 11 o'clock at night. So now my client's got an alibi. Pretty good evidence to go ahead and disrupt the state's case. And keep in mind, as I said before, eyewitness testimony is terrible typically. Nowadays everybody has videos, so that's a different story. But I've seen cases with videos where the videos were so dark or you couldn't actually tell who the person was. And so they didn't help or hurt. They hurt the state's case as far as I'm concerned, because the state comes in here with this great video, but it's so grainy and dark, you can't tell if it's my client or anybody else. And then it works in my favor. So then I'm done putting my case on, and the state can possibly bring in impeachment evidence to impeach or try to take away my case by showing that, well, Aunt Susie's a drunk, Aunt Susie's a convicted felon. You can't listen to what Aunt Susie says because she has no credibility. That's the kind of stuff the state can put on an impeachment. It's been a long, long time since I saw the state bring in evidence after I put on my case when I have. And then it's time for what are called our closing arguments. These aren't statements, these are arguments. And I argue to the jury after the state is done. They get 2 shots, by the way. State argues, you've seen the evidence, you've seen the videotape, the testimony, the admissions, maybe the lapel camera, and they sometimes attack my evidence or my people that I brought in or my client. And then usually this is what I have a passion for, is getting up there and attacking that closing argument. Smart prosecutors don't ever give up their entire argument the first time, because after I'm done, then they get up there and they get their shot on me. So you're not there, neither of the attorneys is there to make people mad or make anybody mad in the courtroom. We're there to do our jobs. And you point out the weaknesses in the state's case. Then the state comes in and they can answer all those weaknesses, and they're the last ones to sit down. They get the last shot because, again, it's their burden to prove you guilty beyond a reasonable doubt. It's not my burden to make sure that you're found not guilty, but it's the state's burden always that never shifts to you for you to prove up your innocence, essentially. So the state sits down last. Then the judge reads a series of jury instructions to the jury, and they've got a copy in front of them, and the judge is telling the jury, you need to take the facts and relate them to the law and look at the elements of the crime, and has everything been met? Has the state done all this? And there's jury instructions for all sorts of odds and ends, like what is the duty of the jury in terms of deliberations, the bias, police officers' testimony is to be given the same weight, expert testimony because this person is schooled or educated in a certain area. And then the jury goes back and they start talking about it. And folks, I wish that I was able to sit on a jury once in my life so I knew exactly what happened. I mean, I don't know if they go back there and eat sandwiches and drink soda or if they actually go back there and talk about the case. There have been plenty of times I've thought that they've gone back there and done nothing, and I've won because it was so short. There have been plenty of times they went back there and I thought they did nothing because I've lost over 3 days. You just don't know until they actually get to serve with other people, and hopefully you all sit down and you're not beating each other up over issues, because sometimes one juror may hold out. He may hold out, that guy's guilty, he was charged and police officers don't lie. Or he may say your client's innocent, they didn't do their job, and then he's trying to convince the other people to go along with him or her. So you really don't know what the dynamics are, and sometimes, most of the time, the jury will talk to you after they've reached a decision, whether it's guilty or not guilty, and you can sit down with them after the trial's over and ask them questions, and I've done that plenty of times, and sometimes what a jury focuses on is completely different than what you thought was important in the trial. It's sort of amazing, and you're like, wow, I didn't think of that, or what are these people thinking, type of thing. And I've had that happen, and good prosecutors have had that happen, and you don't know. You don't know how, in this case, I was talking about 6 people are going to be, what kind of mood they're going to be in any given day. So you don't know how they're going to interact with the other 5 jurors. And there might be one really strong person that convinces everybody to go their way, whether it's good or bad. You don't know. A lot of it depends on luck and credibility and how your client appears in a courtroom. You want everybody to like your client, and I certainly wouldn't say or do anything to make the jury not like me or not like my client. And that's really what happens then. The jury renders a verdict, and the bailiff and or the judge reads the verdict, and I can poll the jurors, hey, did you really find him not guilty or guilty? And the jurors will go one by one and tell the judge in the courtroom exactly how they voted. And then typically if you're found guilty, the case is set off for another 30 days to be sentenced. You might actually have a trial on your prior convictions if you do have prior convictions, because the state's obligated to prove those up too under essentially the same terms as a criminal trial. And if you don't, then you go to sentencing 30 days down the road, and some things are mandatory sentences in Arizona, and some things are not. In other words, the judge may have a lot of discretion, the judge may have no discretion. And that's a problem I see with the sentencing statutes in Arizona, and probably throughout the country, as well as the federal sentencing guidelines, is that judges' hands are tied in case they want to give somebody some leniency. So in any event, that's the way a second part of a trial goes. I hope that's understood. If not, you can email me at chuck@chuckfranklin.com. Thank you.
This posted video is in no way specific legal advice on any subject. It is intended to provide general information for the public. If you need specific legal advice, call Chuck at 480-545-0700.
If you have any questions or ideas for these video topics, please email me at lawyer@chuckfranklin.com. That's lawyer@chuckfranklin.com, and I'll consider your topic, and maybe you'll see yourself on my video channel. Thank you.